So this afternoon we go on with our discussions and we focus particularly on the implications of the European corporate sustainability framework beyond the ideal borders of the European Union, so to say. And of course, the corporate sustainability framework can have several types of implications outside of the EU, political implications, implications for businesses, implications for communities. And of course, it also creates opportunities and challenges, the challenges being mostly about how to implement due diligence in global value chains, and particularly in contexts that present heightened risk, for instance, conflict-affected areas. Today we will touch upon some of these challenges and opportunities with a very excellent panel. In particular, we have Professor Martijn Scheltema, full professor at the Erasmus School of Law, of course, of the University of Rotterdam, Otto Hospes, from the Wageningen University, the Public Administration and Policy Group, Associate Professor. And last but not least, Eva Gerritse from PAX. And all of them will provide a different perspective on the, so to say, extra EU implications of the EU corporate sustainability framework. In discussing this, let's all keep in mind, as Professor Kaufmann reminded us this morning, that regardless of what will happen with this new omnibus proposal, and even regardless of the future of the CSDDD, arguably corporations already have responsibilities under the UN Guiding Principles on Business and Human Rights, the OECD guidelines for multinational enterprises. So even regardless of the future of this omnibus proposal, I think it's important to discuss how due diligence can be implemented and what are the challenges that this process will have to face. So without further ado, I will follow the order of our program and give the floor first to Martijn Scheltema. And Professor Scheltema has led the drafting of the European model clauses. And we are very grateful to have him talk to us about model clauses that might facilitate the implementation of due diligence through what those that are called contractual arrangements in the CSDDD. Thank you so much. You have the floor.
Yeah, it's working. Thank you very much also for the invitation. It's a pleasure to speak at this conference. And indeed, I will elaborate on the European model clauses. Those model clauses are drafted by a group of mainly European lawyers, but also with input from the US and from the UK, because my fellow co-chair is from the US, and that's because the American Bar Association has also undertaken a project to draft model clauses for supply chains. Those were already, I think, published in 2022 or so. They are currently also being revised, but the model clauses are a little bit more recent. We just have undertaken a global consultation on the model clauses, talking to over 700 organizations, business, NGOs, governments, Global North, Global South, to see what they feel of these model clauses and the issues they may run into. And the working group which drafted the model clauses is an independent working group, so it's not part of the European Commission or any European institution, though it tries to align the model clauses with the CSDDD, though that's at this point, of course, a challenging one, but also with the OECD guidelines and the UNGP. So we feel that even, well, regardless of what will happen with the CSDDD, these contractual clauses may stay relevant. Though we are, of course, working in close collaboration with the European Commission, and so the idea is to align, well, these model clauses with also the guidance the European Commission will issue based on Article 18 of the CSDDD as it now stands. And there, I think it's important to realize that contracts are, of course, not the only way to do due diligence, but an important part to try to transpose due diligence obligations throughout supply chains. And what you see here, and especially for Christine Kaufmann, it will be a very well-known picture because it's the OECD due diligence cycle. But what I did is put the articles of the CSDDD as it now stands in terms of the different steps of the due diligence. And so what you see is that these steps nicely fit with the due diligence of the OECD, though of course there are some slight differences. But where I want to use this picture for is to explain how contracts play a role with all these different steps of due diligence. And the first one is to embed responsible business conduct in their own business, managerial systems, even at board level, at least according to the OECD guidelines. CSDDD does not require that, but that's your own policies. And their procurement policies are very important ones in terms of embedding due diligence, because what we see in current contractual models often is risk shifting, a lot of price pressure, last moment alterations. So there are a lot of contractual clauses, termination on every human rights impact. So there are a lot of current clauses in international supply chains which do not, to say the least, facilitate good due diligence. So starting to think about contracts is first looking at your own procurement practices as a company. So that's the first step. Then the second step is identifying risk in supply chains. And there, of course, contracts can be relevant in terms of gathering information on risk, because you want to get risk or acquire information throughout supply chains. So there, that will only happen or can only happen with contractual models allowing this. So there, with this risk identification, there the contractual models can also be relevant. And another thing can be relevant because, where are these contractual clauses most needed? Of course, in the supply chains where the risks are most severe. So in terms of prioritization, that's where the clauses should especially also aim at. A collaboration on remediation or prevention, of course, but also on remediation if companies cause or contribute human rights impact. Their contracts can also be relevant. So the EMCs, the model clauses, indeed include some language on that. Working together and collaborative prevention, or when things go wrong, mitigate or trying to stop impact. Their contractual clauses in how to do this, building remediation plans, understanding on with whom, for example, remediation plans will be shared. That is also a thing which can be arranged in contracts. Tracking results of the measures being implemented, that's information you need, but there, of course, some contracts are often relevant because otherwise you may not have access to the information. And the same thing goes for the communication step, where you also need to retrieve information from supply chain. So we see that with all these steps, contracts can be relevant. And then turning to the CSDDD, it also says, not a lot, but it says something about contract and also has some very important articles which are alluding and implementing contractual practices. Of course, important to see that the due diligence in the CSDDD is an obligation of means, so it's not an obligation of result. So in the contracts, except maybe for providing remedy, but otherwise it's an obligation of means, so that should also be transposed, of course, in the contract. Though the Commission, or at least the CSDDD, requires contractual assurances, Articles 10 and 11 in prevention and addressing impact, but in such a manner that not the risk is shifted to suppliers, but that this is being done in or responsibilities are shared appropriately between the parties. So it's not risk shifting, but trying to collaborate and shared responsibility, so to say, on well, trying to address these issues. And of course, especially SMEs are also addressed because, well, for them, the contractual clauses should be fair, reasonable, and non-discriminatory. And that's also an important thing. Harmful purchasing practices should be prevented and contribute to a living wage, especially, at least according to the recitals, in agricultural supply chains. We see requirements on responsible exit, Article 10 and 11 also, an option to contract with indirect partners, and Article 18 already mentioned, the guidance on model clauses. So we see that the CSDDD at several points is also alluding to these contractual approaches. Where, of course, the implementation of these contractual practices is one of the appropriate measures, as Article 10 and 11 suggest, to address or prevent adverse or human rights impact. And then what's appropriate is also identified in Article 3, so that requires companies and supplier and buyer to reflect on the joint causes of impact when designing measures. They have to implement measures which are effective in addressing impact and are reasonably available and reflect the likelihood of the impact. So that's what is appropriate according to the definition of appropriateness in Article 3. But that also shows that the collaboration between buyer and suppliers are very relevant in terms of implementing appropriate measures. For example, because they have to reflect on the joint causes, so maybe also the purchasing practices of the buyer. Here, and I will not elaborate a lot on this, but this is a translated actual provision in a German contract, and it was implemented after the adoption of the German Supply Chain Act. And well, I'm not going to say a lot about it, but this is one of the examples of typical risk shifting. So apparently, and unfortunately, some of my colleagues, at least in law firms, are also advising German companies on the German law and still advise this type of risk shifting, right? This is exactly not the type of collaborative approaches the CSDDD requires. And also the German law, according at least to the practice of the German supervisor, does not allow this type of contracting. But as seen, well, some capacity building is necessary. Then I will turn to the European model clauses. And of course, we have to acknowledge that contracts are not the silver bullet. So they will not solve all problems in connection with due diligence. It's only a mean to transpose due diligence obligations in supply chains. And it's also the only mean, legally binding mean, to implement such obligations in a supply chain. Because otherwise, in countries where such obligations are not required by law, well, then the only way to implement legally binding obligations is through contract. So they are not the silver bullet, but a necessary element to implement due diligence in a binding fashion, especially with those companies which are not governed by, for example, CSDDD. And we see also in the CSDDD a link between the contractual assurances and purchasing practices, as well as, of course, behavior regarding SMEs. So it's important to bear those elements in mind when contracting. So, for example, the contracting practices I mentioned in the beginning of my lecture, well, those are kind of practices which do not enhance due diligence in supply chain. So like those prices, last moment alterations, termination on impact, those are the kind of things that do not work. And so the CSDDD, but also the model clauses, try to implement a different type of approach. And of course, as said, strive to align with the CSDDD, also align with the European Commission on their guidance, but also UNGPs and OECD guidelines. But for these model clauses to really work, and the interesting thing is in our consultations, several of very large companies we consulted already told that they are actually using the model clauses already, or at least part of it, although it's still a draft and not the final version. But what's interesting to hear. But I think for this project and the European model clauses to really become effective and to contribute to the implementation of proper due diligence require indeed model clauses, because lawyers are often fond of model clauses because apparently some people are doing it, and so then model clauses help to understand what they exactly should do. Of course, the European Commission is important in terms of the guidance of Article 18 of the CSDDD, saying, well, okay, what do we need in terms of model clauses? What are the features we want to see in the model clauses? Public supervisors, of course, looking into model clauses, not just neglecting, just saying, okay, you have a contract, checkbox. No, also looking into contracts in terms of, well, what's exactly in there, but how are you purchasing practices framed? But the most important thing may be that we have to build capacity with lawyers. And I think to the lawyers in the room here, I don't have to explain this, but for many of my colleagues, UNGPs, OECD guidelines, due diligence are a very remote thing, and they are focusing on legal risk. And the moment you start implementing a collaborative approach in a supply chain contract, well, then you accept some risk. And of course, most of my colleagues are trained, at least in terms of contract negotiations, in a manner that the more risk you get to the other party, the better the contract is. And that's a type of risk, legal risk approach, which is not helpful in this case. But then, of course, well, we see problems, people saying, okay, yeah, but you're saying this to me, but well, how do negotiations then occur? Do I just then accept everything the supplier says? No, of course not. But that type of negotiation is not very familiar to them. And how and to which kind of other things they should look into, well, that's still challenging for them. So here we need a lot of education, especially with those contract lawyers who are just, well, into regular commercial contracts, which, well, do not implement a lot of proper due diligence. What the AMCs mainly do in terms of adapting the current contractual practices is, as said, a departure from risk shifting to shared responsibility. So we have to acknowledge it's, well, both parties who have to do and contribute to due diligence. We see or we have implemented limitations in obligations for suppliers to provide information, because what we usually see in the current contractual models are one-size-fits-all lengthy questionnaires, which also even smaller companies have to fill in. Every company is doing audits many times, and so if you have 24 buyers, for example, you have 24 audits, you have to pay for all these audits, so that becomes a huge burden for all these suppliers, and especially the smaller ones. So what we try to do is to limit their information requirements, and, well, make them very effective and focusing on the due diligence, but also making them proportionate in terms of the type of information, and, for example, making it possible for, or at least in principle, for a supplier to rely on audit reports for other companies, for example, and there are some, of course, competition and confidentiality issues to that, but basically relying on those reports if they, well, survey the same type of thing the other parties also want to see. We address irresponsible purchasing practices in terms of the practices I just mentioned. A very important modification is that occurrence of adverse impact is not an event of default as such. And that's a very important one, because usually the contracts have impact, human rights impact, as an event of default, which triggers, for example, termination rights. But in our model, the impact as such does not trigger termination rights, but only an obligation to come up with a remediation plan. And, well, depending on who caused, who contributed, but the parties have to collaborate on that remediation plan. And finally, it includes a dispute resolution provision, which includes an escalation mechanism, but dispute resolution mechanism not between buyer and the supplier, but between those parties and affected third parties. Well, here, but I'm already not talking too long. I think oversight of the clauses in the model clauses, but well, those are indeed those articles I mentioned. And finally, for those of you who are interested to learn more about them, here you see the website at which at least a zero draft is accessible, but currently we are now digesting all the suggestions from the consultations. Then we'll have new discussion with the European Commission, and we hope to publish a 1.0 version in the autumn of this year. Thank you very much for your attention.
Thank you very much, Professor Scheltema. We will certainly go back to these issues in the Q&A. But first, I will give the floor to Otto Hospes. Otto, in his research, investigates the international politics of sustainable food and agriculture. And for instance, he has worked extensively on the controversies between the EU and Indonesia regarding certain European Union's unilateral instruments such as the EU deforestation regulation. And today he will propose his 3 unexposed junctions about the implementation of the corporate sustainability framework. You have the floor. Thank you.
Thank you. Junctions. So my story will be about junctions. I heard the word also junctions this very morning. Heidi saying we are at the critical junction, kind of, are we going to follow the Bible or are we going to work on this moral compass? What battle are we going to play? I like junctions. Junctions, they are, well, important, you know, they can direct, but there's usually also rules that you have to obey or follow. At least this is a place where people could meet, but also maybe laws could meet. And in my story, I will share with you 3 underexposed junctions as a treat to celebrate, you know, kind of the start of this center of excellence, which I think is a super great idea. And I should tell you, I've never been in Ukraine. I've been once in Serbia, but still, I think the story that I could share with you today can also be relevant for you because, you know, I've been more than 40 times in Indonesia, then also many times in Brazil, in Kenya. So let's say beyond the EU. And I think there's some kind of resemblance then, yes, with between Indonesia on the one hand, kind of the land of far, far away for many of you. It's my second home. And also Ukraine and Serbia in the sense that they are kind of, well, not in the center of power compared to the EU. They're fighting maybe accession on their grounds. And Indonesia, Malaysia, major powers in Southeast Asia also fighting for market access and questioning themselves how to relate to the EUDR, how to relate to the EU Green Deal. We have not been there designing but still we see the effects. And I've been talk with many, many different stakeholders, particularly in Indonesia, hearing stories. But so that's a bit about me also. Now about the 3 underexposed junctions. To start with, I would say corporate governance, this is my take. I look at how companies govern processes in the story. And one angle to do so is to kind of emphasize and explore corporate political activity. I heard things also today about that, but I think it should be a field of study. This is the core also of today's maybe lounge. I think we want to discuss how EU laws can help and steer companies moving in the direction of human rights compliance or doing less damage to the environment. This is super good. But, you know, companies, they are also kind of co-governing EU legislators and, of course, EU laws for that matter. In at least 2, and this is a simplified picture, of course, in at least 2 different ways. There's also civil society involved, but through direct lobbying, through agenda setting, Also coalition politics. And the other day I was talking with the ambassador of Indonesia in Berlin, and he gave a clear account of how German polity is operating. A very clear account, showing also me his agenda, like I'm visiting that and that company, then the major of, and then scientists. And with particularly companies kind of also negotiating at the EU in Brussels. So there's all kinds of coalition politics taking place. Companies, they directly lobby, set agendas, and engage in coalition politics, but also through influencing EU member states. And the EU member states and the EU are involved classically in what they call two-level games. So the two-level game theory says when there's a change in domestic politics and policy and polity also, this affects what is being agreed upon or not agreed upon at a higher level. And this may lead to turbulence. I think we're facing legal turbulence, we're facing political turbulence. And this goes through international relations theory, say, through two-level games. With EU member states turning right, then there's a lot of changes also and reconsiderations at the EU level, like we see today. Again, this is a simplified picture, but I would recommend and hope that the Centre of Excellence can also pay attention to the important field of corporate political activity that drives legislative processes. And we have to unpack this. We have to provide transparency. We have to show what happens, how this takes place. This is the way to hold them also accountable. Junction 1 is then where companies and EU legislators meet. This is a black box. We've heard many things, but we need to do scientific studies. Yes, we need to do studies on impact, several of them, not only economic impact, human rights impact, environmental impact, etc., but also show how the game is being played. Detail this, and I think this could be important for the center. This is the junction. So companies, they're not sitting ducks, but they co-govern legislative processes. Also, maybe to some extent, there's more to say about that, explaining this simplification and streamlining now taking place or being put on the agenda. The much quoted omnibus law, but also the discussion on the EUDR that we have seen, adding a no risk category or putting the traders out of the text. And this is not only to do, say, with corporate political activity, there's more to it. As I said, the two-level game has to be followed seriously. There's also change in political regimes in different countries, which explains also the current things that we see. Detailing this is important. Yes, I believe in corporate sustainability laws, but I also want to add it can be magic and can also be misleading. Like Almeida said 1.5 years ago, can you imagine? Presenting and unpacking in her now famous article the European Green Deal as the EU First agenda. With C arguing and her colleagues that ecological crisis being taken as an opportunity for business and the EGD reproducing, these are strong words, yes, a colonial capitalist ideology, deepening the hegemony of resource imperialism. So under the guise of the EGD, there is resource extraction being safeguarded and with European companies being the first to profit from it. This is a short story of her article. You can debate, but maybe we could also say like that the current developments show the true nature of the European Green Deal, where it's clearly going in a direction and under the influence of Draghi's Bible, and now manifesting itself very clearly. So maybe Almeida was right, and the true nature is now manifesting itself. Yes, we also have to be critical on these things, and certainly when there's the influence of companies involved, or certain companies, we cannot, of course, put them all in one basket, then this seemingly nice instrument may have a different background, reason, drivers. And I think it would be too simplistic to assume that there's nothing more. There are things happening. The second, I go to the second junction, and then I have to explain something about corporate governance as navigating in a regime complex. So what are regime complexes? Mind you, Indonesia is not a country characterized by institutional void. There's many kinds of private, public, and also self-regulations in this country. This holds for every country outside the EU, and maybe also inside the EU. But outside the EU, I'm more familiar with it. The regime complex says, this is also driven by ideas on legal pluralism, there's a mix of three partially overlapping regulations, and more important, three overlapping claims to authority over commodities, territories, trees, and or people. So all three regulatory or legalities or regulatory complex, they claim authority. And this could be private regulation of round tables and stewardships. We've seen a rise in proliferations in the 90s and the zeros of that. We've seen the proliferation also of public regulation of state agencies, also in Indonesia with standards, but also in the European states, a proliferation taking place, and also corporate self-regulation that we have seen examples to it. So regime complex says, hey, these are, overlapping, partially overlapping regulations. And yes, I'm not going into detail, but to give you a kind of an idea, what are the relationships between these elements? They can be disconnects, so not at all related. Private standards and public, not at all connected at all. Antagonism, there's conflict, or complementarity. This is, of course, the nice case. This is very quickly put. I can tell you much more about that, but you get an idea of a regime complex. This is an example from a field I'm very familiar with, in palm oil, where you see state regulations on the left, but also private standards, both the, roundtable forms, but also, which is on certification, but also the self-regulation types. These are examples. And every country outside the EU has this regime complex. And here you go. What is the junction number 2? It's where EU corporate sustainability laws, the whole bunch, certainly on their kind of extraterritorial effects and reach. I mean, this is also a debate, a concept we can debate, but where they meet with public, private, and self-regulation. Again, these countries, the global south, or let's say not even bigger, non-EU, is not an institutional void. So there's need to think of the relationships between these regulatory complexes. And we have to question ourselves. Certainly in Indonesia, this is a question. Are EU sustainability laws beyond the border like bulls in a China shop? I mean, there's so much of close to anger, like, what are they doing? Don't they understand that we have the forest moratorium, that we have the ISPO on palm oil, that we have all kinds of regulations that slow down deforestation? And now they come with, don't they understand? We had the Vlecht as Europe for deforestation, which was there, put in place after 12 years of negotiations. And then overnight, these ... come with the EUDR. Can you imagine the kind of, this is not fun. They feel like this. Last one. Corporate governance as corporate contentious politics. Why is this important? This is about the practices. This is about what companies do to win conflicts with communities. It's the efforts of corporate actors to make and realize claims bearing on other actors' interests. Okay, this can be communities, villages, and resources, which means their land, their forest. And yes, in which governments are involved as targets or third parties. The third and last junction I'd like to share with you, this is about conflicts between companies and communities at the upstream part of global value chains. We have nice regulations, also EUDR, etc. There's work to be done on it. or getting it simplified, but how it really works on the ground and how communities feel about it, cope with it. This is another story. And what companies do on the ground, this can be a totally different story. This is Indonesia. It's as huge as Europe in geography. And I was involved in a study, a 5-year study, 544 conflicts, sorry, between communities and palm oil companies in Indonesia in 4 provinces. These are the palm oil producing provinces. And yes, they made pledges, the companies. This is the tip of the iceberg. Standard operating procedures, nice. Special sustainability directorates, okay, tick the box. Certification schemes and supporting them, RSPO. But this was not visible. The cooptation of local leaders as a standard practice. So we talk about companies like Sinarmas at national level, international level, but their subsidiaries and suppliers are playing these games. Not seen. And we need to show something that is underneath the practices under and of corporate contentious politics. Cooptation of local leaders. Do you want your son or daughter to have a study? Yes or no? Cultivation of connection with local authorities in the same. There's a lot of story about that. Suppression of community protest. I've seen many of them. I mean, this is serious. The criminalization of protest leaders. They're the bad guys. Put them in prison. And this is not about one company. It's widespread. So, and the breeding grounds, but this is a big story as well. It's about political economy, the close relationship between political and economic powers in Indonesia. And you may say, hey, this is Indonesia. But mind you, this also takes place in Germany and in the Netherlands and in Norway and in Italy. This is not a strange word. This is not an exotic word. Informalized state institutions. Decisions made on kind of informalized relationships and not on performance and service provision. And insecure rights to land and forest for citizens. Maybe this is a bit of unique feature for many countries in, say, the global south. But these are breeding grounds for corporate contentious politics. It can play on the insecurity of access to land and forest for citizens. It's their battlefield. Well, scientists, they are always kind of proud on what they publish. Hey, here's the book. But we presented at the 12 Indonesian universities. Kampan Hak means empty rights and meaningless rights. We had a presentation in Indonesian Parliament. We made a movie of 1.5 years. We had policy briefs at regional and national levels. And this book, it's great. Yeah, hey, you know, it's my moment to be proud. It will be translated in English and appear at Cornell University. I think studies of contentious politics of communities and companies, they are needed for 2 reasons. To redesign and critically reflect on corporate sustainability and human rights laws. Yes, the insights from what happens on the ground in these struggles can help to redesign, I believe, but also critically reflect. What can we assume on what happens in a situation where there's so much of land insecurity? So that's also need of critical reflection. I think that is what science is doing, or should do. And develop hobby horse at Wageningen University, the place for interdisciplinarity. I worked for 12 years with the law group. To develop interdisciplinary and transdisciplinary approaches, so combining knowledges of different peoples, that can change what companies do. Congrats to the Center of Excellence. The ending starts today. I got it from a famous song. The ending, of course, of negative impacts of business transnational activities on human rights and the environment, and wishing you inspiring junctions.
Thank you so much, Otto. So we have started to navigate the complexity. First, we have looked at how model contractual clauses could facilitate implementation in global supply chains of due diligence obligations, responsibilities in general. Now, Otto has shown us how these processes outside of the EU will not take place in a void, but actually in a complex institutional, political, social context. And now we will look at particularly complex contexts that are conflict affected areas, and we are lucky to have here Eva Gerritse from PAX. PAX is an organization that is doing amazing work, among other things, on corporate accountability in context of occupation and conflict, and Eva leads the business, human rights and conflict project. So Eva, you have the floor.
Still on, yeah. Thank you very much for the introduction and also for the opportunity to participate in this panel and in this super important day, of course. I'm always a bit nervous when I'm standing in front of a group of people, especially coming after two professors, so you'll have to bear with me. Yeah, as Chiara said, I work for PAX on our business conflict and human rights program. We research and publish about corporate abuses in conflict-affected areas. We work together with affected rights holders in claiming remedy and justice. We also engage and advise corporate actors, especially also financial institutions, on how to conduct business or how to invest responsibly in conflict-affected areas. And we advocate with policymakers for more effective norms and standards and laws in this field. So I'm super happy that Jeroen is here, because that is what I'm going to do now. Yeah, so quickly diving into it, I'll start with briefly laying out the general framework of responsible business conduct in conflict-affected areas, and then proceed with an overview of what the CSDDD provides in this regard. So, yes, considering the increasing number of armed conflicts in the world and the increasing also protractedness of these conflicts, more and more businesses will find themselves operating in or linked to such environments. In conflict-affected areas, businesses are at a heightened risk of becoming involved with severe human rights abuses, because contexts of armed conflict and widespread violence are inherently rife with negative impacts on human rights. Business relations, such as local suppliers or other actors, can be active parties to a conflict or to the conflict, and the government can be unable or unwilling to protect human rights, or can be an active party to the conflict. And the management of these risks is also more complex because of the operational environment. Companies can also unintentionally exacerbate existing grievances and tensions, or even create new ones. So in short, companies, their presence and their activities, they never take place in a sort of isolated bubble. They're never neutral in that, if you want to call it like that. They always have an impact on the conflict, as well as vice versa. So conflicts always impact the company and its presence and its activities, for example, also its own staff. And also, importantly, next to involvement with human rights abuses, companies can also get involved with and even face liability for complicity in violations of international humanitarian law, if their activities are connected to an armed conflict or indeed a military occupation. So to effectively address these heightened and context-specific risks, the UNGPs and the OECD guidelines, they prescribe that heightened action is necessary from states as well as from corporations. For corporate actors, this means that they need to conduct enhanced or heightened, or sometimes called conflict-sensitive human rights due diligence. So this means that in addition to identifying human rights risks and impacts, companies need to identify and address their adverse impacts on conflict and ensure that they do not cause or contribute to conflict in addition to human rights abuses. What this comes down to concretely is that companies should conduct a conflict analysis as an additional layer to their standard or human rights impact assessment. So this conflict analysis should be aimed at the mapping of root causes and triggers of the conflict, the dynamics, the actors, their motives, their capacities. They need to assess the interplay between conflict and human rights, and also assess, and that's important, how their own presence, their own operations, their services, or products are impacting conflict, so how they are impacting societal relationships and tensions and vice versa. So this analysis needs to be regularly updated, also to account for what is an inherently dynamic and quickly evolving context. It needs to be based on broad and robust stakeholder engagement, including with actors that are specialized in this specific element. Well, this conflict analysis should be at the base of appropriate measures, an action plan, if you want to call it like that, aimed at preventing contribution to conflict in addition to human rights impacts. And this also includes proactive early considerations regarding a potential exit and how to do that responsibly, or how to remain responsibly. And next to conducting a conflict analysis, as I said, in situations of armed conflict and occupation, companies also need to take into account international humanitarian law and ensure that they respect IHL. Well, there's much more, of course, to be explained about the how of heightened human rights due diligence, but there's actually excellent guidance out there, including by UNDP again. So what does the CSDDD provide in this regard? The initial proposal by the Commission did not address in any way conflict-affected high-risk areas, nor the standards for responsible business conduct in these areas. Despite not only the human rights risks in these areas, but also the potential material, financial, and legal impacts for companies themselves. And also despite the fact that many EU companies are doing business in conflict-affected areas or with. The Parliament's negotiating mandate that was published in June 2023 did include an explicit heightened human rights due diligence obligation, actually largely due to the efforts of Ms. Houtela's group. I think she's left now, but they were really sort of like a front runner in the Parliament on this topic. But in its final form, being of course the outcome of an intensely negotiated process, the CSDDD has let that explicit obligation go. The directive does now contain a recital that addresses conflict-affected areas and touches upon what businesses should be doing. So, I'm paraphrasing now, but they acknowledge that it acknowledges that human rights abuses are in these areas more likely to occur and to be severe, and that companies should take this into account when designing and implementing their due diligence processes to ensure that they're adapted to the specific risks. What is good is that they mention the separate phases of due diligence. So both the identification and assessment phase, but also when taking appropriate measures and when engaging with stakeholders. It also mentions consistency with international humanitarian law, but IHL is not part of the sort of like official normative scope. It's not in the annex. So this is a recital. I'm not a lawmaker. I'm not exactly sure what that means, but in addition, there's Article 19 on the guidelines, and it states that the Commission shall issue guidelines on general due diligence, but also on more sector-specific or other specific risks, including on conflict-affected and high-risk areas. Hopefully these guidelines will more clearly communicate expectations of companies in this regard, and it will hopefully also clarify how companies can identify and assess and prevent contributing to IHL violations which is a field of law that's, well, not very well known, I think, still by and understood by business actors. When it comes to effectively addressing corporate involvement in conflict, there's also some major weaknesses in the CSDDD, more in general, but also specifically with this issue, which I want to address very briefly. So one of the key weaknesses, I think, of the CSDDD is that it does not explicitly mandate due diligence on the majority of downstream relationships and impact, so including the sale and use of products and services. So, for example, let's say a producer of heavy machinery needs to conduct due diligence on the materials used to assemble his bulldozers, but does not have to do due diligence on where those bulldozers go to. Also not if those bulldozers are supplied to a government that builds illegal settlements in occupied territories. So that's what I mean with the downstream, the lack of downstream due diligence. It also goes, for instance, for the sale and use of surveillance software, other digital technologies that play important roles in conflict nowadays. And it's unclear and vague, actually, a bit, but it's highly likely that it's meant in this way and will be interpreted in this way, the text. What is very clear and explicitly excluded is the arms sector, which I also want to mention when we're talking about conflict-affected and high-risk areas. So arms producers are explicitly excluded from the due diligence obligation. They do not need to conduct due diligence on arms, weapons, dual use, items that they sell after an export license is awarded. So I think this is quite a major deficiency because arms companies, of course, supply large amounts of weapons to areas marred by serious human rights abuses, violations of IHL, where the risk of that is very high. Well, this explicit exclusion, of course, goes completely beyond the fact that all companies, including arms producers, have an individual responsibility to conduct their own human rights due diligence independently and irrespective of what the government does. Its willingness or ability to fulfill its own human rights obligations. And as we have seen, I mean, definitely in recent times, and also close to home, that not all states are able to fulfill these obligations. And I think especially in the area of arms export licensing, this has clear gaps and deficiencies in this regard. It's a totally different topic again, but the arms sector is often, I think, a bit overlooked in the business human rights field, so I wanted to mention it here. That's it.
Wow, thank you. Much food for thought. You can take it actually, because you can also then use it to answer the questions, which I hope will come from the floor. We have about 20 minutes for a Q&A. So if there are any questions, yes, Ezra?
Yeah, now it's working. Yes. Hi, thank you so much for all your presentation. I think they're all very insightful. I have a question regarding EU's external action, but then towards its trading partners, because it's coming from my own background, of course, but I'm very curious how you see it, that there are a lot of sustainability obligations in EU's trade agreements where third parties, so trading partners, are being encouraged, sometimes with soft obligations, but sometimes also with legally binding obligations to make progress in terms of sustainability, so environmental protection and labor standards. I'm wondering what for role that you would see in engaging trade agreements and using EU's market as sort of the carrot for also pushing countries, so to say, if not encouraging our trading partners to move also forward with corporate sustainability. For instance, with module clauses, like in bringing an article in the trade and sustainable development chapters might be a start for it. So is there a role for trade agreements as we see it generally for sustainability that could also be translated for corporate sustainability? Thank you.
Thank you, Ezra. Are there any other questions? Because otherwise we could put, yes, let's put 2 or 3 of them together.
Hi, thank you very much. My name is Ben Garmer. I'm a postdoctoral researcher at Ghent University. I found the presentations very interesting, but my question is specifically for Otto Hospes and the call that you made at the end of your presentation to try and take perspectives on the ground and bring them to top-down initiatives. And I hear that call made very often, and it's a very pertinent and important call. But one of the things that I always think when I hear about that, and it's of course your presentation ends there, you know, how do we actually do that is very difficult. And one of the things about when we're looking at these kind of due diligence laws is that they are very legal, very apolitical. They're about creating obligations that are dischargeable and bring closure to a particular set of events, whereas the struggles that you're referring to in somewhere like Indonesian palm oil are struggles that go on and are inherently political and inherently don't lead to closure and ongoing dialogues. Laws are very monological. There's a single set of facts. You apply a single set of norms to reach a single conclusion, whereas these kinds of conflicts have many different truths and voices and lived experiences. And it's very difficult to look at a situation like that and see how that informs a law, because it's inherently just a completely different framing and different reality to the reality that law depends upon. And I wondered if you had any comments about that.
Another question here.
Hi, Yilde Garst here at Wageningen Business Management and Organization Group, Assistant Prof. My question is also to Otto on his presentation. Thank you, first of all, very insightful. First on clarification, you mentioned 3 things. Can you explain a bit what you see, how you see the difference between self-regulation and the top one, private regulation, just for non-policy experts in-house? And then also, you mentioned the deforestation regulation now from the EU bulldozering over, maybe a nice word for deforestation, but local initiatives, local regulation. And I see from my perspective as sustainability accounting background, I see that the regulation of the EU is also built on voluntary standards, such as in corporate, the CSRD is built on practices already in GRI and other reporting standards. And do you think in this instance, you mentioned that it's bulldozing over, so is it not being informed by the best practices on the ground, or is it just, it is informed by the regulational practices, but not on the business practices on the ground? Do you see a distinction there?
Yeah, let's take one last question before we allow the speakers to answer. Nadia? Yeah.
Thank you. Yeah, my question is for Martijn. Thank you for your presentation on the model clauses. This is really, I mean, you managed to make contract law actually exciting, which frankly is it's extraordinary. But I wonder if you could say a bit more about your ambitions with these clauses. I mean, what's the ideal scenario? Obviously, you would want them to be used by companies, but I wonder if you have a strategy perhaps already on how to make this happen, and how can we help? Maybe there's people in the room who could help you with that process. This is very nerdy, lawyery kind of work. This is very interesting. I thank you for your presentation. Yeah.
Okay, then let's. Yeah, sure. Sinisa, there's another question.
Thanks. I was going to have a similar question. Actually, my question is about, I mean, I had a very quick look, reading diagonally at the website that you put up, and it said that consultations were held. I mean, there was 65, 75. Sorry if I'm misremembering the number, but what kind of concerns have you heard from the people you consulted, but the real life application of model clauses. And I don't just mean for the companies themselves, because I can imagine that they will, that they will have concerns. But what about, others? I mean, other stakeholders in the chain. And then I'm going to sneak in another question. Sorry, I have the mic and I'm not letting go. And the question is for Eva and for Otto, to the degree that you can, because it seems to me like your presentations are related to each other in a way. I mean, maybe it's more of a question of Otto, but also for Eva, I guess, which is how in these 544 situations, contexts in Indonesia, how does the, this paradigm of conflict-sensitive due diligence, how could it apply? I mean, from what you've heard, would that be something that would alleviate any concerns of these communities and so on, or would have these companies behave more responsibly on the ground? Thanks.
Great. Let's give the floor to the speakers. Maybe we can start with Otto.
Yeah, as quickly as possible. Asian trade agreement, it also goes the other way around, that the Asian trade agreement is being used like, okay, one thing, but get our regulations in. So it is also a place where indeed there's a battle on environmental standards. But it's a strong battlefield, certainly for countries from the global south. No trade agreement if there's more acceptable terms for us in it. I find it fair from their perspective. Yeah, due diligence on the ground, super difficult question. Maybe two answers. One is to working on the implementation of due diligence and on risk classification of a country, parts thereof, because this is the text in the UDR, and maybe also commodities, and to at least sit together with government authorities, and maybe also at the level of provinces and districts. I know this is huge because these same districts and provincial governments may be very closely tied to businesses. So you can make that get in a negative spiral. In this research, we work together with 16 NGOs. I mean, a lot of our findings, and that's also a debate, was this reliable material? We trained them for 1.5 years to do research, but they were able to see a lot of things and also report on it. So then you get to a bigger question, like how can you provide the question of, this is also echoing the question of Nadia, like the role of civil society. Yes, civil society also at the upstream part should play a role in reporting and in witnessing and in showing and in discussing. This is a big issue because it's about democratization processes in a country, but it's one of the, I think, best ways to kind of come to more transparency on what companies do. Self-regulation and private regulation. Self-regulation is, for instance, in the Indonesian case, an IPOP, which is agreed by companies themselves. They commit to zero deforestation. So the zero deforestation commitments of companies, there have been a wave of them. And private regulation in the literature is to refer to kind of the round tables where businesses together discuss and set standards for palm oil, for soy, for cacao, etc. Yeah, EU bulldozering, nice term. Tragic, of course. But again, many players, both business, also government, also NGOs in Indonesia feel like, hey, we took such a long time to negotiate the Vlecht, 12 years, as I said, and now why? Why overnight? And businesses also have difficulties with that. Like you can see it in the reactions. Like they want to temporize. I'm not saying that Indonesia is the one that caused the delay or the kind of the application. It is much more complex. It's at the European side, I think. But there were many protests like, hey, this goes too quickly. And we have been working since 2011 in this case, so for 14 years on complying to the Indonesian standard for sustainable palm oil. And now in 2 years you expect us, hey, come on, this does not make sense. So yeah, and the last question, my God, on conflict sense due diligence. Yeah, I think I come back to my first answer. I think one of our recommendations, and that is also sensitive in the Indonesian context, was to really give more room for NGOs, to research NGOs, for advocacy NGOs to make their case. Interestingly, we find also an air with quite some players at national level. Government players said, hey, we didn't know. So interestingly, we had a kind of coalition of government agents at the national level and NGOs reporting and doing research who were in the same boat, who, were formed a coalition. And we played these cards. Like, and of course, facing big opponents. I mean, this is playing chess with a giant. So this was not super easy. It still not is. But in the first place, this kind of documenting of these so many conflicts was smashing. I think made a strong impression, and life is not easy. This is all I can say now.
Thank you. Perhaps a reaction from Martijn and Eva.
Thank you, and I shall try to be even briefer. In terms of the trade agreements, I think it's a very interesting and also, I think, intriguing question. A PhD of mine graduated on the sustainability requirements in trade agreements 2 years ago, but not Asian only, but more broadly speaking. And well, her conclusion was that there are a lot of agreements which include some language, either between the negotiating partners or even for investors on corporate sustainability, though usually, especially for investors, not binding, though depends a little on what kind of approach you seek, because sometimes compliance with national laws and making investments is a kind of access kind of barrier, but or at least, well, if you do not comply, then jurisdiction may lack. But usually the big problem is enforcement by those affected by what the investors do. So there, I think, is a huge gap, because we see nice examples. The model bit of the Netherlands, for example, also has some interesting, well, at least model clauses which, at least in theory, address these issues, but enforcement is the big thing. And so with my colleagues of the Hague Rules on Business Human Rights Arbitration, we have written a piece for the Uncontrolled 3 Working Group, which is currently rethinking trade agreements. And we try to come up with some ideas on how to address that gap. But yeah, that is, I think, the big challenge in this field. Then to Nadia's question, in terms of, do you already think of implementation of the clauses? Well, actually, I must admit that we have been a little bit modest, because before the consultation was completed, we thought, well, we have to see what stakeholders think of our clauses, and maybe they feel it's crap, and so, well, then makes no sense to start implementation processes. But luckily, virtually all stakeholders told us that this would indeed be a good way forward. Of course, they have more detailed suggestions, also depending on the type of stakeholder you're talking to. But, well, they feel it's a good idea. So, indeed, when we have, also in collaboration with the European Commission, finalized the 1.0 version, well, then, of course, the implementation process starts. It was, by the way, interesting to hear that some companies are already using them. But yeah, we really have to also at that point, and also depending, of course, how the omnibus will turn out, whether or not the Commission will be very interested to work with us on that as well, really depends on what stays in, I think. But anyhow, we feel that that will be felt very helpful. And well, your offer is much appreciated because we will probably need all the help we can get for the implementation process. And I think academia could also be very instrumental in that. So that's much appreciated. Then your very challenging question, okay, but did you also discuss this with affected stakeholders? Because, well, do they feel it's a good idea? And well, what we got back from mainly, well, we have talked to several CSO, including the ILO, by the way, on these clauses and well, how they feel those will work out in practice. Well, the main reflection is, well, the proof of the pudding is in the eating. So when companies start using these clauses, well, then, well, we are curious to see what happens. We have some limited examples from garment industry. Well, already Zeeman was already mentioned, and they have a two-way code of conduct, which kind of implements this shared responsibility approach. And well, what we got back from for example, talks with ILO is that, well, the perception is that at least works better also for workers than well, the traditional risk shifting method. But yeah, the proof is still a little bit anecdotal. But yeah, the problem of course is and I can understand that they say, yeah, but we really have to see what happens if companies really do this. And so it's that's still challenging, but you're very right. I think in the implementation phase, it will definitely be necessary to also start talking to those stakeholders to really learn whether, well, the effects we think the contracts have are indeed realized. And that's also a point of the 1.0 version. It's by purpose called 1.0 because we do not think it's then a one-off thing, but we envisage to keep on working, maybe also on more sector-specific clauses, for example, but also to implement kind of reflections we get from, for example, affected stakeholders.
Yeah, sure. Yeah, with regards to what Sinisha brought up and on the overlap also between our presentations, I'm not familiar with the context in Indonesia, but I think it sort of excellently showcases how important it is to incorporate conflict sensitivity once you enter, but also when you're active, these kinds of areas. And I guess there is a lot of, like, there might be differences and localized issues going on, but also a lot of commonalities or patterns that you will see and that should be sort of like identified. I like the picture that you showed about the iceberg and especially the lower part of the underwater part of the iceberg. Like, these are the kinds of issues which get companies involved with, you know, these kinds of situations, I think, and that needs to be brought, brought to the, what do you say, the surface, I guess. But yeah.
Thank you very much for this very interesting discussion. We now have half an hour to continue the conversation over coffee, as we say, and then I hope to see